Welcome to everyone. Welcome to everyone, especially a very warm welcome to Justice R.C. Chauhan and Justice Gautam Patel. These are both very honorable, very well known judges, and we are very happy to have you here. Welcome to all other Indian citizens who have joined this. We all have joined with one purpose to understand the working of virtual courts and how we can implement this. Let me give you a small figure which led to this exercise. From 2006 to 2017, over a 12-year period, the total backlog of all the courts put together increased by 55 lakh cases in 12 years. In 2020, the backlog has increased by over 70 lakh cases already. This is like saying another 12 years delay has been added in just 1 year. Unless we go for virtual courts, I think we have a problem. Therefore, we've got this, and we've got two very eminent people to do this. Justice Chauhan is on the committee of the Supreme Court, and Justice Gautam Patel, I believe I've heard from lawyers, has been doing far more in terms of hearing of cases, etc., than most people, and therefore he's taking a lead in organizing the virtual courts. So I leave it there, and now we'll have Mr. Praveen Patel introducing his organization and the judges. Over to Mr. Praveen Patel. Mr. Patel, unmute yourself.
Yeah, it is now muted. Okay. Yes, sir. Good evening, everybody. I am Praveen Patel, Honorary Trustee of Forum for Fast Justice, Mumbai, that works to create awareness on need of judicial reforms all over the country, specifically at 200 districts, through societies for fast justice that are working in 25 states since last 13 years. We are associated with National Federation of Societies for Fast Justice for access to justice also. It is my pleasure to introduce you Honorable Justice Sri R.C. Chauhanji at this webinar. Honorable Justice R.C. Chauhan has done Master of Laws in securing the highest number of marks from Nagpur University. Justice Chauhan joined the judicial service in March 1976 and was elevated in June 2005 as Judge of the Bombay High Court. Justice Chauhan also served as the President of the Maharashtra State Consumer Commission from September 2013 to October 2015 and has been associated with IT initiatives in courts for last 25 years. Justice Chauhan is presently the Chairperson of the E-Committee of the Supreme Court. Now I request Sri Venkatraman, Honorary Trustee of Forum for Fast Justice, to take over to introduce Honorable Justice Sri G.S. Patel. Venkatji, unmute yourself.
Yeah. Hello. Yeah. Thank you, Praveen Bhatt, and thanks to Shailesh Gandhi for organizing this webinar. It's a great honor for me to introduce Honorable Justice Gautam Shirish Patel. He is a Mumbaite like me. He has graduated from Government Law College, and he was, and later in 1987, at the age of 25, he started his law practice. And during his practice, he specialized in commercial law, corporate law, civil litigation, and his main passion was on PIL related to environmental protection. And the noteworthy cases amongst his environmental issue on the PIL were the Sanjay Gandhi National Park issue, protection of mangroves, town and country planning issues, mill land, protection of open spaces, which was all widely covered in all the newspapers. And the in 1994 and 95, he was awarded the first international fellowship on environmental law by the Pacific Energy Resource Center based in Berkeley, California. He also served as a honorary secretary of Mumbai Bar Association for 6 years, and later on he was in the standing committee till his appointment as a Mumbai High Court judge in 2013. And he was also a lecturer in administrative law, constitutional law, and environmental law at Government Law College. And he regularly wrote several articles and columns in Mumbai Mirror and other newspapers regularly. He also served as a trustee in several public charitable trusts and foundations in the field of education, hearing impaired, and environment. And also the managing intellectual property that this thing, which mainly covers the trademarks and patent this thing. He was certified. He was awarded. He was noted as the 50 most influential people in intellectual property rights in the year 2014-15, and yeah, staunch supporter for RTA movement. And he has his noteworthy comment on the RTA Act was a government committed to democracy and the Constitution has nothing to fear from information and dissent. And any government that discourages dissent and autonomy of ideas is not a liberal government. What a noteworthy comment by Justice Gautam Patel. Though we all address him as Honorable Justice, today, sir, you have honored all of us by agreeing to participate in today's webinar. And today we will be talking on virtual courts, and that also I had the opportunity to introduce you virtually. And thanks for the honor. We are really fortunate to have you with us. Uh, with
Thank you,
this,
Mr. Venkat.
yeah.
Thank you, Mr. Venkat. Now I invite Shreya Yadav to speak about, to introduce the other organization that's sponsoring this, the Public Concern for Governance Trust. Public Concern for Governance Trust and Forum for Fast Justice have both helped to organize this. Shreya Yadav, please.
Thank you so much, sir. Good evening, everyone. I am Shreya Yadav. I am a third year law student and I am a lead campus ambassador with Public Concern for Governance Trust, PCGT. I am also serving as the president for the PCGT National Youth Parliament. The Public Concern for Governance Trust is a registered trust founded in 2002 by Sri Julio Ribeiro, Dr. R.K. Anand, and late Sri B.G. Deshmukh. Founded on the principles of accountability and transparency, PCGT has been working towards the cause of good governance. The various projects undertaken to fulfill this mission are the Youth for Governance Project, the Kuch Aur program, and the RTI RTS training session. The Campus Ambassador Program is another opportunity that PCGT has presented to students across Mumbai and Pune to work towards the cause of good governance in their own institutions. The PCGT National Youth Parliament, organized every year, is another such initiative wherein students are given a platform to take up issues of national importance and to learn about the Indian parliamentary procedure. With this, PCGT has been working tirelessly towards the cause of good governance. Thank you.
Thank you very much, Shreya. Now I'd request Honorable Justice Ravindra Chavan to give us his address. We are all looking forward to this, and that will be followed by Justice Gautam Patel talking about his experience and his views on our virtual courts. Justice Ravindra Chavan, please, sir.
Good to all of you, and thank you, Mr. Gandhi. Thanks to two organizations for giving me this opportunity of sharing this virtual dais with Justice Gautam Patel. I am sure with Justice Gautam Patel being present here, what I speak will not be cries in wilderness as my earlier attempts have been. Forum for Fast Justice deserves compliments because it has brought to the fore an issue which needs to be discussed by all. India has a population of about 135 crores, and there are a staggering 3.50 crore cases pending in about 18,000 trial courts, of which nine, 91 lakh 70,790 cases, that is about 1 crore cases are pending for over a year, over 1 to 3 years. 47 lakhs 98,000 cases for 3 to 5 years. 48 lakh 83,000 cases for 5 to 10 years. 22 lakhs 99,000 cases for 10 to 20 years. 42 lakhs 24,000 cases for over 20 years. And a staggering 86,153 cases are pending for over 30 years. There is a case in Calcutta High Court which is pending since 1951, that is before I was born. So we need to find some solutions, some quick solutions to deal with these cases quickly. The figure in the High Courts is also equally grim. There are 56 lakh 16,623 cases pending in various High Courts. Of them, 11 lakh 65,224 cases are pending for 1 to 3 years. 7 lakh 26,350 cases are pending for 3 to 5 years. 10 lakh 44,000 cases are pending for 5 to 10 years. 8 lakh 92,000 cases are pending for 10 to 20 years. 1 lakh 25,000 cases are pending for 20 to 30 years. And 85,000 cases are pending for over 30 years. And there is a case, as I told you, in Calcutta High Court, which is pending since 1951. And if I am right, it is an execution petition. So you can imagine when the parties must have filed the first motion in the case. Now, in these 3.63 crores of cases, minimum 5 to over 3,000, over 1,000 sheets of paper are filed, average being about 100 sheets in each case. Every day, about 30,000 cases are filed in various courts, even in this lockdown. You can just imagine the number of trees sacrificed for this load of paper which comes to the courts. And imagine the space consumed by these pending cases. I am not counting disposed of cases. And also imagine the dust in the courtrooms because of this huge pile of papers. On an average day, in the 18,000 trial courts, about 9 lakh cases are listed. Every case has at least 2 parties and there are 2 advocates. Sometimes witnesses too are called. So for every case listed, at least 5 persons have to visit the courts. So about 45 lakh persons or 1 lakh busloads of persons come to the court every day. Apart from their time lost in commutation, commutation creates pressure on public transport and adds to pollution. Since Justice Gautam Patel is an environmentalist, I suppose he would be more concerned about these aspects of our judicial administration. Now, we must use, India has been a leader in information technology. In fact, it is our boys in the United States who have made a significant change. So therefore, we must use this technology to tackle the issue of pendency, tackle the issues of mountain load of paper being pushed in the court and bus loads of people rushing to the crowded courts. You can visit courts in Mumbai. They are overcrowded, including the High Court of Bombay. In corridors, in busy days, it's difficult to move. This year, I am proud to say that our e-court services has received Digital India Award for Excellence in Digital Governance. Now, this acclaim or recognition does elate one, but also makes one realize that there is a long journey ahead. We have received an award. We are going to get that award on the 30th this month at the hands of the President of India. But that award will be meaningless if we cannot take this journey forward. If we cannot ensure that the technology tools which are available are fully exploited to make delivery of justice fast and inexpensive. Among many of our initiatives, our chairperson, Dr. Justice Chandrachud, prioritizes 3 issues. First is paperless courts and e-filing. Second is e-courts, where stakeholders have an option to appear virtually. And third is virtual courts, where parties need not at all appear physically. Now, paper-based courts is something which is not new. In fact, it began long ago with Justice Muralidhar of Delhi High Court starting his court without papers. E-committee has enabled e-filing. Almost every application, pleading, document, everything can be filed electronically. The process is also very simple. Even a party and its advocate need not be at the same place to sign and verify the papers to be filed. They can do it from the leisure of their homes or offices. A document drafted by an advocate could be sent to the party and the party could authenticate it by either e-signing it or through an OTP generated by using Aadhaar number. Even for making an affidavit, a party need not go to court. A link will go to the party, and on clicking it, the party has just to record a video verification, even on the smartphone. I suppose most of the members of your organizations may be familiar with registration of directors in companies, DIN. For that, you record a video, and that's good enough. You get a link on your smartphone, you read out the content which is displayed on the screen, and that ensures that you are joining, you're allowing yourself to be registered as a director. So there is no reason why this can't be used by courts. This technology can't be used by courts. Now, this is not used because courts insist on filing hard copies of e-filed documents and applications. Now, Justice Gautam Patel kindly consider and kindly persuade all the brothers in the Bombay High Court. Why will an advocate or a party go for e-filing if it has also to file a hard copy? Now, all documents are in fact prepared by advocates on their computers, on their laptops. Then they are printed, then they are signed, and then they have to be scanned, converted into PDF, a machine readable PDF, and then uploaded for the purpose of e-filing. Now, who is going to do all this? This is called Dravidi Pranayam in Marathi. Who is going to do this Dravidi Pranayam? So this has to be avoided. But then why do courts insist on hard copies? Because there are some presiding officers who may not be comfortable with paper-based environment. But younger officers must be happy to work with paper-based environment. When I say this, I include officers who may be more in age, presiding officers or judges who may be more in age like me. I am 68 and 3/4, that is 68 years and 9 months. But I am young at heart, no? So I consider myself to be a young officer who is happy to work in a paper-based environment. For older officers or judges who find it difficult to read on a computer screen, what we could do is the registry itself could print only those important papers which the judge wants, not all the papers. You please realize that at least 3/4 of the cases which are pending in courts are criminal cases. We have implemented an interoperable criminal justice system. This has been implemented in Maharashtra fully, and almost all states are also covered. So all criminal cases which are filed by police as well as other prosecuting agencies of the state can be filed electronically. In fact, police now record statements of witnesses also on their computers or laptops. So charge sheets also generated on laptops. FIR, if you have seen the police stations, FIR is also recorded on computers, recorded and stored in computers. So these papers are available in the criminal justice system digitally, and they can be pushed to the courts. All our magistrates have been provided with laptops. All our courts have been provided with enough equipment, enough infrastructure for running a paper-based court. Now, therefore, as far as these courts are concerned, no paper should be coming to the courts. Courts should insist that no, we are not going to accept any paper. Only if the accused person insists on hard copies, that set can be printed by police itself, just as they are doing now also. For accused, for providing copies to the accused, police prepare extra sets. So paper will not remain in the court, paper will go to the offender. Just imagine the saving of trees, storage space which will be saved, and dust-free courts. We will not have cluttered courts. Another bulk of pendency in criminal courts is under the Negotiable Instrument Act. Now, these cases under 138 of Negotiable Instrument Act form a big bulk now in the criminal courts. All these cases could be filed electronically. And most of the complainants in these cases are financial institutions or banks. Therefore, they would be more comfortable in filing cases electronically. Even those who have lent money or are to receive money would like to do it easily by sending a digital complaint rather than filing a physical complaint. If we cannot have paperless courts, at least let us consider having less paper courts where we could avoid whatever can be avoided in physical form. Now, in high courts and other courts also, a number of papers are just procedural papers. For example, registered address, process fee payments, sundry applications, and mostly adjournment applications and circulation slips. If one examines any court record, these papers occupy at least half of the bulk. They could be easily filed electronically. Why do we want this paper to come to the court? Writ petitions in the High Court are invariably filed against functionaries of the state. Now, these functionaries of the state are all on, they have email addresses provided by the NIC. So therefore, they must be forced to receive copies electronically. This can be done immediately. There is no need to wait for any initiative, any amendment for doing this. If we do this, we could at least reduce a bulk of paper from the courts. If we eliminate that paper, I think our courts will look a bit better. People will be happy to visit courts rather than the present atmosphere of dust, dampness, and a dull atmosphere which dampens even spirit of a person like, say, Mr. Shailesh Gandhi, who is a die-hard optimist. Now, this is about paperless courts and less paper courts. The next initiative which the E-Committee is taking is about e-courts. Now, is physical presence of parties and advocates really necessary at all the hearings? If you examine the record which is available on the National Judicial Data Grid, and I would urge the young lady who was an ambassador for an organization who is in third year of law to check the data on National Judicial Data Grid with the help of her friends. You will find that on any day, and Justice Patel will agree, 3/4 of the cases which are listed before courts get adjourned without any substantial business being transacted. So therefore, if 3/4 of the cases get adjourned without or rolled over without any substantial business being transacted, why should parties and advocates be forced to remain present for such hearings? This, in my humble view, is atrocious and speaks poorly on failure of an activist judiciary to remedy this. When the judiciary, which takes initiative in removing so many ills in other segments, other walks of life, other parts of governance, why it can't set its own house in order? Why it can't clear these Asian stables? Parties or advocates or even witnesses need not be compelled to appear physically when it is almost unnecessary, absolutely unnecessary. Therefore, I would urge that let us request the courts to ensure that only those persons whose presence is absolutely necessary in the court are required to appear in the court physically. Now, we are a poor country. Every day in these 18,000 courts, out of these 18,000 courts, about 12,000 courts are criminal courts. In these 12,000 criminal courts, or say, let us take half of these criminal courts, 6,000 criminal courts, at least one doctor, medical officer from our poorly manned public health service is required to appear. All of us would agree that our public health system is poorly manned. Many times there are no doctors in a primary health center. So we summon about 6,000 doctors every day in courts. You can imagine the doctor traveling from his place, his dispensary, his hospital, to the court for giving evidence for half an hour, maximum 1 hour. For that 1 hour evidence, he has to spend at least the whole day in traveling. And who pays for this? The poor patients who are waiting for a doctor in the public health system. Therefore, this is atrocious. This is really unthinkable. Why we can't eliminate doctors appearing in courts. Now, some initiative has been taken, and many doctors or many surgeons are allowed to appear via video conferencing. But let us ensure that unless it is absolutely necessary, a doctor from public health system should not be called to the court. This is not all. People have not a very fair opinion about our police machinery. True. But yet, all of us will agree that our police machinery is poorly manned. We don't have enough of policemen for maintaining law and order, for tracking crime. And we have also a lot of VIP duties for policemen. Therefore, in fact, half of the police force is at any given point of time defunct. So remaining half, which is working for cracking crime, has to appear in courts naturally. You know, when an investigating officer investigates, he has to appear in the court. Imagine a police officer who receives a summons to appear in the sessions court on a magistrate's court and has prepared, is ready to go. But a serious crime takes place in his jurisdiction. What does he do? Does he go to the court first, or does he look after the investigation, which is to be done immediately? Therefore, let us think of eliminating appearance of police officers also to the extent possible. Many policemen just carry some samples from police stations to the forensic science laboratories, etc. These people need not at all come to the court. Their evidence can be recorded virtually by video conferencing. Therefore, let us ensure that our poorly manned police force also gets some reprieve in the form of e-courts. Now, I had the good fortune of having never been an advocate. Therefore, I was not required to wait for my case being called out in the court. But as a judge, I have realized that I had to wait for an advocate, say like senior advocate like Gautam Patel, coming to my court, because he will be busy in some other court. But advocates have to every day wait in courts for their cases being called out. Sometimes the wait is for the whole day, and whole day is wasted in sitting on a bench in the court in the hope that the case would be called out. But of course, this helps advocates, as my son, who is a young advocate practicing in the Bombay High Court, tells me that sitting in the court is educative because you come to know the judge. You come to know how the judge feels, how the judge behaves, or what the judge is likely to do when you are going to argue. That's true, but still, the time wasted by advocates in waiting in the courts is not at their cost. It is at the cost of the litigant. When an advocate takes a brief, he factors in the time which he will be required to spend in courts waiting for the case to be called out. Arguments are sometimes 5 minutes or 10 minutes only, but waiting is endless. So therefore, he factors this waiting time when he fixes his fees. And who pays? The poor litigant. Therefore, if you want to make justice really inexpensive or less expensive, let us ensure that time of advocates is also respected and they can appear at the appointed hour. Just as now Mr. Shailesh Gandhi called me to speak. So he had told me that I should join at 5:58. That is just 2 minutes before this conference was to begin. We could do it. In fact, we have created a system, and Justice Gautam Patel has been using it, where an advocate waits only for 5 to 10 minutes, 15 minutes for his case to be called out. He's in the waiting room. The moment a case hearing begins, he is ushered in the hearing. Therefore, the cost of legal services would come down if we ensure that the advocates can join from their offices rather than crowding in the courts. There is an advantage because when the advocate is sitting in his office, he can also do his other work. He can utilize that time more profitably and earnings can go up. A senior advocate who's practicing in the Supreme Court as well as several high courts from Bangalore told me that, sir, I spend more time in waiting at airport lounges than actually appearing before the courts. Therefore, and flying from one destination to another. He says that this virtual hearings has helped me. I can do a lot of more work in several jurisdictions without moving an inch from my office. This reduces the cost, or this may increase the income of the advocate, either ways. So this is going to help the profession as well as the common man. Adjournments, which are a common feature on account of advocate being busy in another court, in spite of a specific provision of law to the contrary, can be avoided if we permit advocates to appear via video conferencing. Now, after e-courts, the third initiative of the e-committee is virtual courts. As contrasted with e-courts, virtual courts do not at all require the presence of stakeholders. There are several types of cases where hearing can take place in an asynchronous manner, that is, where all need not come together at the same time. Traffic cases is a glaring example. In Delhi, over 125 crores in fines have been recovered in the last 1 year. I repeat, 125 crores have been recovered in fines by virtual court in Delhi in just 1 year. Now, those fined are also happy to honestly pay the fine than bribing the cop, because going to the court, even for pleading guilty, is very costly. First is time wasted in going to the court, then waiting for the case to be called out. Then whenever the magistrate feels like the person has to stand up and say that I plead guilty, thereafter the file has to reach the account section and then stand in a queue to pay a fine. All this has been eliminated. You get a chagan, you get a summons on your mobile, and you can pay electronically from wherever you are. So if I jump a signal, say at Hutatma Chowk, by the time I am near CST, I would get a chagan, I would get a summons. And by the time I proceed to say small cause court, I would have paid the fine electronically. Matter is over. And this court, virtual court, is working 24/7. It's not that virtual court is without a presiding officer. There is a presiding officer who decides on the quantum of fine. These presiding officers go on working in a shift. But then in Delhi, when about 10 judicial officers, 10 magistrates were doing this traffic business, now we have got only 3 magistrates who are looking after this work. So 7 magistrates have been freed from this duty. We have attempted to start virtual courts in Maharashtra also. One started in Pune but faltered. I don't know the reasons. But if we can have even one virtual court for Western Maharashtra, one for say rest of the Maharashtra or something like that, and we can free up the judicial officers who are occupied in this time, in this business. Now, it is not that just traffic chagans can be dealt with by virtual courts. Virtual courts can deal with any case where compounding or plea bargaining is permissible. At least till the compounding or plea bargaining fails, the virtual court could deal with the matter. Even in regular contested matters, all proceedings where synchronous hearing is not necessary, that is, parties could file the motions or arguments in the absence of adversary, would also be taken up by virtual courts. These motions or the arguments which are to be filed could be electronically exchanged between the parties and resolved even without a hearing many times. You can, those who have been visiting courts, particularly trial courts, would find that there is a lot of hassle on which date is to be fixed, next date to be given. When lawyer A says that, say, 10th of January is fine for me, lawyer B immediately looks at his diary, possibly a blank page in his diary, and says that, no, 10th I am very busy. So keep it on 14th or something like that. So this hassle is also avoided because this electronically exchanged motions or applications could be decided without a judge being required to spend his time. Thus, this will ensure that the judges actually devote themselves to adjudicatory work rather than spend time on things which only increase the temper in the court. So what is judicial administration waiting for? First, eliminate paper in magistrates court. Use interoperable criminal justice system and ensure that no magistrate here receives any charge sheet in physical form. Reduce paper whenever it is possible. Avoid personal hearings unless it is absolutely necessary. And push as many case types as possible and as many stages in all proceedings as possible to the virtual courts. Vasundhara, the Mother Earth, will be grateful if the judicial administration takes up this initiative. I spoke so much about environment basically because Justice Gautam Patel is an environmentalist. But this e-filing or virtual courts or e-courts is not only about environment. Once we usher e-filing, storing of all pleadings and documents electronically, we can use artificial intelligence for assisting the stakeholders. Today, if we use the circuitous route for things which are otherwise simple, the parties are discouraged from filing proceedings electronically. And since parties do not file the proceedings electronically, what does the administration have to do? The administration then scans those documents, engages some agency in scanning the documents, converting them to readable, computer readable PDFs, and then store them in the cloud storage this AI committee has, e-committee has provided. And then an AI engine, artificial intelligence engine, seeks to read it and find out answers. We have got an artificial intelligence committee of the Supreme Court also. Justice Nageshwar Rao is the chairperson of that committee. It has commissioned some work in this area. We have engaged some experts and we have made substantial progress. As far as criminal cases go, the artificial intelligence engine which has been developed can answer over 100 typical questions arising in criminal cases. For example, what is the offense which took place? Which weapon was used? Which is the place of offense? What time it occurred, etc. Whatever questions come to the mind of the judge or the lawyer. So it becomes easy to find out these answers, and then this answer also takes you to the page concerned, on what page this answer is to be found. Therefore, you don't have to shuffle pages in order to reach the answer. But had we had all these cases electronically filed by now, the AI engine could have rendered marvelous results. Chief Justice of India, Justice Bobde, is trying to push use of AI in assisting lawyers and judges. Now, once we have a case electronically filed, the machine can tag with that case all the relevant provisions of law, all the relevant judgments from all courts across the country, not just for the use of the judge, but also for the lawyers, for the parties, so that you don't have to search anything for yourself. Everything will be readily available. We are not making a decision. Please remove the doubt in your mind that artificial intelligence is going to remove the judge or the advocate. No, it's not like that. We are just going to assist the lawyers and judges in providing updated information. Suppose a new judgment is rendered today in respect of a matter which is already pending, in respect which is relevant for a matter which is already pending. that judgment will also be updated in the file, in the folder which the advocate gets. So therefore, this will help everyone in coming to correct answers, finding out correct solutions for the problems which are before the court. Instances where judges or lawyers, uh, push arguments in ignorance of law will not be there, or judges deciding cases in ignorance of law will not be there, because there will be no excuse. Everything will be there before on their screens. Therefore, this artificial intelligence is also something which requires us to eliminate paper, eliminate physical hearings as well. Because once the evidence is also tendered electronically, the person, his face, everything is recorded. When the matter goes to appellate courts will also find it easy to decide the matter by, say, replaying the entire evidence, which is otherwise not possible. If the trial court records evidence incorrectly, wrong words are used, there is no correction, nobody can correct it. Therefore, I urge all of you to please plead, urge, pray to the judicial administration to ensure that all these initiatives get a push from all of us. Justice Patel has been in the forefront. We are right now working on rules of live streaming of court proceedings. Justice Patel started virtual hearings and allowed live streaming immediately. He would give an open link to everyone so that everyone can join. So, open courts which are open to public scrutiny, is ensured by live streaming. We are also working on that. And I suppose this entire initiative, if implemented, if pushed by every one of us, will change the change the fortunes of common man who comes to the court. His faith, his confidence in the system will be enhanced. I thank the organizers for giving me this opportunity of sharing a few thoughts and sharing this virtual dash with Justice Gautam Patel. Thank you.
Thank you very much, Honorable Justice Chavan. This was brilliant. It made me feel as if I'm dreaming about an India that one should strive for. And this is simple. This lot of work has been done. But I'll just share with you one very senior Supreme Court retired judge told me, he said, Shailesh, 20 years back also we were talking about this, but we did not do it. So I wish we bring the change, and I wish all those who are participating today contribute to bringing that change. And you and Justice Gautam Patel are obviously amongst the leaders in this. Just one small piece of information I'd like to share with you, sir. 10 years back, as an information commissioner, I used to run a paperless operation without any papers. And video conferencing is an established practice in the Central Information Commission. So I'm sure the judicial system can do it. And that would reduce a lot of pain and time and expense for everybody. Now I'd request Justice Gautam Patel. I'm sorry, but I'm not used to adding the honorific earlier. So I keep saying Justice somebody instead of saying Honorable Justice Gautam Patel. But I would request Honorable Justice Gautam Patel to please enlighten us on this topic. He has done phenomenal work in this, and we'd all love to know. And how do we take it forward, sir? Justice Gautam Patel.
Thank you very much. Please interrupt and tell me if I'm not audible at any point. It's wonderful being here. Thank you, Shailesh, PCGT, Forum for Fast Justice, for organizing this. I do believe this is an issue of the moment, one that we cannot fail to acknowledge. I'm especially delighted to be here with Justice Chavan and with Mr. Vivek, both of whom I know. My acquaintance with Justice Chavan goes back to the days when he was Registrar General, before he was even in the High Court. And I was in practice Back then, he was, much as he was on the bench, determined, completely clear-eyed about where he wanted to go with the administration. And, well, talking back early days, he was even then something of a visionary when it came to process change. We hadn't got to quite the level that we are today, but Justice Chavan has been committed to that enterprise for the better part, I think, of what, 25 years, Judge? Yeah, something along those lines. Justice Mr. Ribeiro, I know personally, and it is an honor beyond description to have him here and to be with us. He embodies so many things to another generation, not only the essential need for integrity in public service, the need for accountability, and that even after you're out of service, to spend your days and your energy serving the people in a citizen-centric manner. That's not a common thing, and that's why I really value this. There are, Shailesh, of course, I have known in bits and pieces. I don't necessarily agree with all of his theories, but some of them we will debate on another day. One of his pet theories is that if you have more judges, you solve the problems of the judiciary. I don't agree with that, but we'll discuss that in another session or whenever. The year began, I'm talking January, February 2020, on a fairly innocuous note, and I don't think we were all alert to what was coming our way. And then we hit March, and we literally got the plug pulled on us. Now, let's just understand what exactly this really meant, because where we were, what we did, and where we are today is a trajectory and an arc that will explain to us and tell us where we go from here. Suddenly, everything that the judiciary was used to doing quite comfortably, despite Shailesh's demonstrations that we could do considerably better. All the comfort went out of it. Suddenly, this was up in smoke. It was just gone because we were told nobody could go to the court, nobody could come to court, and nobody could argue a matter in person. Complete disaster. Now, this is where perhaps we distinguish ourselves from other professions. Medicine, for example, a doctor does need to see a patient and to analyze it and be hands-on. The realization then was, I think, very quickly, that we didn't need the physical exchange and the physical presence. I'm an eternal optimist. My opposite parties always believe that every silver lining has its cloud, to invert the proverb. We'll come to that in a moment. But there is one great, and I truly mean this, truly great thing that came out of the COVID pandemic was the virtual courts. Now, let me be clear about this terminology so we don't cross wires, especially for the Q&A between Justice Chavan and myself. When I'm talking about virtual courts, I really mean e-courts, where people argue matters, rather than virtual courts such as a traffic challan court, which is a different thing. So, okay, I'll use the word e-courts. What this did in March and April 2020 was to literally kick us into the 21st century. Some of us may have been reluctant. Some of us were unaware. We were all apprehensive. I did a very early hearing somewhere around the first week of April. I think Justice Chavan attended that hearing, virtual hearing. There were a couple of mistakes along the way. There were 500 people allowed in. It was on a Zoom platform. By the way, it wasn't live streamed. Live streamed is what is happening just now, where it is being relayed simultaneously on another platform such as YouTube. The session that I did was not live streamed. It was only open access, which is a policy I have maintained throughout ever since. The actual cap may be different, but I never actually allow this to be televised remotely. I need to know who is in my court. I have different views on the live streaming, but that's a matter for another discussion. Now, we used to be slow, ponderous, and suddenly we had this new system. I myself had never used any of these platforms. Some of them I'd never even heard of. I was vaguely familiar that something like this existed and that other places in the corporate world especially were using them. People were using them as a pastime and so on and so forth. Now, this became our go-to choice already. I'm going to jump ahead a bit, and then we'll come back. Flash forward from April 2020 to December 2020, and let us ask ourselves this question. Because this will set the stage for everything that follows. Is it possible for us in December 2020 to go back to the way we were in December 2019 or in January 2020 or February 2020? I don't believe it is possible at all. I do not think it is even advisable. E-courts and hearing by video conferencing, and I'm making this statement now, I'm committing myself to this as a sitting judge, is here to stay and it cannot be wished away. We can't do it. I'm going to come to the reasons for it now, but let me make this abundantly clear that this is in fact my position. There are several problems, some of which Justice Chavan has highlighted. I'm going to illustrate this with examples from my own court and going to give you in the next few minutes instances of how my court has managed and some of the changes that I've been asked to make. But let's go back to a theoretical aspect to this. First, why would we want now to get rid of video hearings and video conferencing and e-courts? Unless somebody is able to demonstrate with empirical evidence that e-courts are less efficient, more costly, and do not serve the purpose, there is no reason to abandon. In fact, the empirical evidence is to the contrary, that they are very cost efficient. They have other efficiencies. What is lacking, and I must tell you honestly, I miss it as a judge too. There is a certain ineffable, undefinable quality to having a top-notch advocate arguing before you and you being part of this performance, some of which is lost in the virtual court hearing, the e-court hearing. But I think that's a small price to pay. The price that many, and I must say I have been tempted as well, because there are other issues with the video hearings, is that let me get back to my pleasant courtroom, my space, be comfortable in my chair on the dais, hear advocates physically. There's the give and take that happens between advocates. All of this we miss and will continue to miss. I am not suggesting, and let me make this clear as the second point, that virtual courts or video conferencing courts can or should entirely substitute for or displace physical courts. I'm not suggesting this. In fact, there is a category of cases where it's inescapable, but we will come to it. I am saying that the video conferencing option is here to stay. Whoever needs it must be allowed to use it. It's not something that can be done away with. And in a given case, a judge may insist and impose that we will do this by VCPL. Now, there are two elements to this. So let's be clear about that. One is the paper management and the case paper management and the digitalization of that. And the second is the actual hearing on an online platform such as the Zoom platform that we're dealing with. These are two separate things. They come together in a video conferencing hearing as we've experienced it up to now, but they don't necessarily have to go hand in hand. We can have a fully digital case paper management system with physical hearing. You can do digital paper and a digital hearing. There is no reason at all to continue with physical papers and physical hearings in the manner that we have. Now, let me just say this. The example you gave, Shailesh, is correct. People have been talking about this for a long time, and Justice Chandran should, I have no doubt Justice Chavan will tell him I said this, but please do. As the head of our Supreme Court E-Committee, is unfortunately has to wear a crown of thorns. He has to take this in easy steps. He can't force the change. My view is going to be at the end of this somewhat different from this. And it is true that we've been talking about much of this for a long time, but giving it optional, so it never got done. COVID forced this upon us, and that's the positive takeaway from all of this. Why is it more efficient? Several factors. One, there's a huge saving in time when you file electronically. There is accuracy, ease of replacing lost data, the diminished chance of lost papers because they're all in physical files. Your hard disk crashes, it can be reconstructed. That's not a problem. It can be re-downloaded. That's not a problem. It's efficient for advocates who are able to appear in multiple jurisdictions in a day, which they could not have done. And from the perspective of a litigant, it's hugely cost saving because you do not really, the litigant does not actually have to pay for an advocate to travel from Mumbai to Delhi, put him up in a hotel. This advocate can appear from anywhere he likes. Now, my experience is that I've had advocates, seniors and entry level, from Chhattisgarh, Telangana, Madras, Northeast, senior counsel from Delhi, senior counsel from Ahmedabad, all appearing, including law officers, and there's never been a problem. They've logged in on time, we've had the cases, we've heard long arguments, judgments have followed, reportable judgments have followed, long hearings in complex cases have all taken place. Let me put it differently. There is nothing that has happened in my experience in the VC courts from April to December that I could say, this is something that I could not have done in a VC court. I would need a physical court for this. There's been no such case. There has been no such case. Anything that I could have done in a physical court, I've been able to do in a VC court. There is one possible exception. I haven't had to handle it, but I anticipate it's an issue. I want to just deal with 2-3 fundamentals before I go on to tell you what my experience is and how I've gone about it. One, please let's understand that all this software that we're using, WebEx or Zoom or Jitsi, none of it was meant for courts. All of it was meant for boardrooms, corporate gatherings, and things like this. We have willy-nilly adapted it to our purposes. This is unviable. We need a dedicated software for the Indian judiciary, which serves our purposes and does what we need it to do. I need, for example, a software which allows, across the board, when there are 2 judges in a division bench, that they can move into a closeted area where they can have an open discussion in what is called a breakout room and come back. Now, some software platforms offer this, not all, and everybody's using a different platform. That has to go. It should make no difference to an advocate which court he's in. The software must be one for the judiciary, not for every court within that judiciary. That is an absolutely essential fact. We have questions of sharing documents that happen during the course of an argument. Now somebody emails it to me, I download the email. We should get rid of all of this. File transfers must be able to happen simultaneously, and we should be able to look at those just as somebody would hand up a document. On the hardware in Maharashtra, we are encountering a peculiar problem. I don't think that it's open to a public institution like a court to say, we don't have the infrastructure, because the answer to that simply is, well, get it. Nor is it open to an institution to say, or a government, sorry, not an institution, a government to say, sorry, we can't provide the funds that you need for the hardware to run a justice delivery system. That's just monstrous. We are not doing this because we are playing video games on these things. Quite the contrary. If I need a 2 Gbps line and I need the large monitors which have built-in cameras, built-in microphones, the 100-inch monitors, I need them for a reason. Courtrooms may need to be remodeled, especially in the older courts such as Mumbai, Calcutta, Madras, Karnataka. Newer courtrooms like Ahmedabad, Gujarat, and Delhi may not. It's not a competition about who gets to spend more money. The money must be spent as needed. The Bombay High Court's remodeling is undoubtedly going to be far more expensive to make every court hall video conferencing enabled than an equivalent court hall in, let us say, Delhi or Ahmedabad. But look at our strike rate, look at our success rate. Which High Court has not effectively delivered on video conferencing? The answer is zero. All have come forward. Ahmedabad, across the judiciary. Karnataka, and I know this because Chief Justice Abhayok is a close friend, they have used the virtual courts, they have transitioned back to physical courts, they have kept open an option of video conferencing even in the physical courts. They've remodeled their courtrooms and their trial halls. They have done all of this, and the bench headed by Chief Justice Hope has heard a Supreme Court expedited matter to deal with Franklin Templeton, with advocates from all over the country, all appearing virtually. No problem. Judgment rendered on dot. No difficulty. So what's the disadvantage? None. To this system, there is none. There's one basic mantra. There's no difference technically, between a boardroom and a courtroom when you're dealing with this technology. If a board meeting can happen with video conferencing, so can a court hearing. There's no problem. People who were used to traveling first class to foreign places and staying in five-star hotels for board meetings, they have also discovered that this is a thing of the past. The other thing that has happened because with advocates is that there's a great benefit to a middle order level of advocates who in the physical world would not ordinarily have got a brief to travel because of costs. They are now able to appear in various courts. I'm mindful of the comment that our Chief Justice of India made, and I think it's a valid point, that we have not, in all of this, made sufficient provision for those advocates who lack the necessary resources. But that only means that we have to modify our systems so that they are accessible even to those. In fact, if you look at it today, on a cell phone, I don't believe there is a cell phone plan that is available without data. I don't think anybody has a cell phone plan that excludes data. Data is bundled with all of it. Once you have a data-enabled plan, you are actually enabled for virtual court access. It may not be stable, but it will work up to a given point. We need to get to a better signal area, but that's the difference. Now, this takes us to where we need to get with what is going to be the future, which is at a minimum a hybrid model, which is that your courts will sit, advocates will be allowed the option to appear, but there will be available a virtual court facility. So he who cannot, maybe for health, maybe for age, maybe for distance, will have the option of appearing in by video conference. You know, we should take a step back. We're talking about these vaccines, but there are peculiar numbers coming out of UK. We know where US is. Maharashtra's cases seem to be fluctuating up and down. I can't read them correctly. But I am not at all confident that vaccine or no vaccine, that we are going to be able to eradicate this virus. It's going to stay with us just as its predecessor variants have. And it will flare up now and again in various spots. There may be a bigger outbreak. We have to make the arrangements now to be able to revert to this awareness. Now, let me give you a couple of things about what I've done. We moved to the WebEx platform, which is okay and has improved a great deal. I still think the Zoom platform has many of the features that we need, but well, whatever the reason, I don't want to get into that. One of the things that we must do is that the judges or the judicial officers who run their courts, and I'm talking about judges at all levels, they must either have their immediate staff extensively and intensively trained, or they must train themselves in how to deal with this. Now, lots of people tell me that, I'm comfortable with technology, etc., etc. I wasn't familiar with this video conferencing technology. In April, I just figured that we would have no choice, so I had better get on top of it, which is what I've done. Now, between my court clerk and I, we've streamlined a system that works seamlessly. We share an email account, filings go into that email account, there's a Google Drive. We got additional space on that Google Drive, so we've got 100 GB, which is more than enough for our purposes. Things are downloaded at his end, things are downloaded at my end. He prepares the daily lists using Google Docs and Google Sheets, so we don't have to go outside that ecosystem for any purpose whatsoever. When we prepare our lists, one of the things that I began doing fairly early is giving time slots. I realized that what Justice Sawan mentioned was going to be an issue, and I did this with, three purposes in mind. First, I thought this was a courtesy to the bar and a recognition, acknowledgement that their time is also of value. The second compelling concern was that if I don't give time slots, then a person at serial number 44 comes and camps at 11 o'clock, which means that at 11 o'clock, I've got 177 people either in the waiting room or admitted entry. I solved the problem by giving 1 hour time slots. The person who knows his case is listed as not before 4 o'clock or 3 o'clock doesn't log in at 11. He's free to do whatever he wants to do. He can go to another court, he can go for a walk, he can go and have a swim. I don't care. There have been times when I ran ahead of my list, but that meant I had to wait for 5 or 10 minutes, which was fine. I just muted all of this, grabbed myself a cup of coffee, and I was back in 5 minutes or 10 minutes, and we carried. There were more frequently times when my list ran late. But the advocate whose case was at, let us say, 1 o'clock, logged in at 5 to 1, but didn't mind waiting 20 minutes. He didn't have to wait 2.5 hours. So this has worked, and frankly, this is something that will translate into a modified version of a hybrid court, part physical and part virtual, for another reason. This allows us to maintain social distancing in the physical courtroom also. So in a physical listing, when I tell a lawyer that your case is not before 12:30, he doesn't leave his chamber till 12:25 or 12:20. He doesn't crowd our court halls, and we don't have the problem that Justice Sawan mentioned of overcrowded courtrooms, Right. Now, there are three things that are lacking, and we really need to address this much more aggressively. We've recently got communications from the E-Committee. I can speak for my colleagues in Bombay or who are on the Computer Committee that we are not only solidly in support, but we are really going to move this. Let me explain what's happening here. As Justice Dhawan said, it's a upside down process. In fact, I'm going out and saying it's an imbecilic process that you manualize an existing digital record. It's absurd. You have created the document on a computer to print it physically, to sign it, and then scan it to re-digitize it. Makes no sense whatsoever. It does not even make common sense. On the one hand, there is an entire separate enterprise afoot to digitize our existing physical records. If we have that going, we cannot be adding to the amount of paper that we are handling. It makes no sense. Of course, it's a question of the environment, but it's also a question of standardizing. And with respect, Justice Dhawan, and please carry it to wherever you are able as a request from me, we must force a standardization across the judiciary. There has to be a standard, not for the court, but for the Indian judiciary. The last few months, we've had news reports of this High Court has issued notice on a PIL file to use A4 paper. What's the big thing about it? The government has been using A4 paper for the last 15 years. They have no other kind of paper. Their offices can't afford them. Scanners best work with A4 paper. Foolscap scanners are too expensive. It's fine. We know this. Oh, what is there to think about? Every court must be provided with an auto duplex front and back A4 printer. Scanner. You have to do this. If you need to print it, it must print back and forth. Second, I don't understand why we need certified copies if you've got digital signatures. Why are people going on with certified copies? The MCGM does not issue a factory license. It does not issue a physical shops and establishments license. It does not issue a physical dog license. All of these are digital. But some tehsildar will say, I want a certified copy with that red billa stuck on it. For what reason? For what reason? Where are we going with this? Process serving. We need process serving in this fashion where somebody has to go to a remote district in Maharashtra, take a signature, send it back by post. I don't get the report for 5, 6, 8, 12 weeks. Of course, the cases get adjourned. But the comparison is not that. The comparison is in that very remote village, there is a chai shop where the man is selling Pepsi products like wafers, Lay's wafers. How does he restock? He goes there with a handheld device, looks at what is required, puts in the requirement, and it gets shipped. Now, from this to process serving, actual process serving, transmit the file to the lowest denomination court, hand over the papers, take his photograph, scroll on the screen, that report reaches my court within minutes. Of course, I can't take it up in minutes because that poor fellow has to log in somewhere. Now, put this all together. He gets served. The case is listed 2 days later. He has an online link. It is open access. He logs in. Case can be heard. What's the inefficiency? There's none. There's none. I had an advocate who was in Telangana saying, I'm in a forested area. I could hear him perfectly. He said, I need to get back to Hyderabad and take instructions. I said, all right. So when will you do that? He said, Tuesday. I said, okay, Tuesday. Tuesday he got listed. We finished it. There was no problem. Now this also happens. We can make that accommodation. People say we should not dismiss cases or should not pass adverse orders. All right, maybe not on the first occasion. I give 2 chances. I gave 3. In one matter, I gave him 6. The person deliberately not appearing to avoid an order, I pass the order. Now do whatever you need to do. I can't keep the case hanging merely because VC is an excuse. It's not. It can't be. There are enormous efficiencies to be had. I do believe that open access is important, and I'll tell you there are two reasons. One is that the old practice that you have to see the judge doing what the judge does. Anybody must be able to walk in and see this. There are also cases which are outside the PL, which are public importance. Journalists need to come in. My only restriction has been, please identify yourself by name and your publication. Once you do that, you're in. Now, what the other efficiency here is this. I do not generate a fresh link per day or per case at all. The Bombay High Court now, thanks to the Supreme Court, has enough licenses per court. Each court has its license. My license is fixed and has not changed in 4 months. It has not changed in 4 months. It's listed on the daily list. Nobody needs to send the other side the link. This is the link. This link will be live. That's just inefficient. The link is there. It's on the printed list with a PDF link. Click that link. You're in the session. I have also found that I no longer need to even maintain a waiting room, which I do occasionally, because people have learned how to conduct it. There are also more controls now for muting everybody except the speaker. We have more features that have been added. So I have no problem. If you put all of these things into play, timings on your lists, open access, listing your matters and dividing your case like this, it's an entirely manageable setup. One of the areas that I have been saying for a long time is the need to standardize. Shailesh, just give me 2 minutes and I'll be done with this.
Patel, please go ahead.
We need to standardize for the judiciary, and I mean we need to standardize everything. The software that a court uses, the login protocols that are used, the filing protocols that are being used. It should make no difference whether you're filing in the Bombay High Court, in the Civil Judge Junior Division, or in the Supreme Court. The filing protocols must remain the same. The High Court and Supreme Court websites, we are now looking at a makeover, and Justice Chandrachud has given us more guidelines on that. We'll attend to all of that. There should actually be a standardized format. Now, I have no idea why one particular High Court needs to have a website that looks bright and chirpy, and the other High Court needs to look more sedate and sad, and why things are organized differently. This is, most importantly, the entire search mechanism is different from court to court to court. That is actually user unfriendly. There has to be a unified search interface. In fact, my vision is one search interface for the whole judiciary. Specify the court where you want to search, and it will search that. It's an interlinked database. It's a network of networks. There is no reason why sitting in Bombay, one search form shouldn't show me judgments of Tripura, Guwahati, Madras, and Supreme Court on one screen. Why do I have to go to each of these sites separately? I should not have to. But within that, every single High Court must look and feel and operate in the same manner, so that when Mr. Shailesh Gandhi, who is an activist and an enthusiastic citizen, decides he needs to find a case from the Delhi High Court, and he's used to finding them from the Bombay High Court, he is not suddenly encountering a strange interface with which he is unfamiliar. Absolute standardization is absolutely key to this. I'm not dealing with this question of adjournments. That's a complex issue. I don't really tolerate them very much. I've had 1971 suits coming before me and people asking me for 12 weeks' time. And everybody knows the mantra in my court. This is almost automatic to advocates. The case comes up, I need 4 weeks' time. So what do you need 4 weeks in this day and age? In my court, we'll be lucky to get 4 days. You've got a stenographer, you've got a computer, print. Start dictating. Why do you need 4 weeks? What's going to happen in 4 weeks? Oh, my client is in Dubai. The client has a cell phone. Call him. He's not on the dark side of the moon. Where is the question of giving more time? These time frames can be compressed. The problem with implementation is, I think, something that may be uncomfortable and may not even be workable. The problem is that we give choice. We give high courts the choice. We give high courts options. We give high courts time. This needs to be far more ruthlessly and dictatorially done in the interests of the litigant. We have to push it down hard from the top, saying this is what we want done along these parameters, on these templates and guidelines, and this is the date by which you will report compliance finished. Don't care how you do it. Take away the problem of choice and force the change into the next century. This is the only way we are going to be able to build on the solitary benefit that we got from COVID. If we go back, and I'm really apprehensive about this, I really apprehend that we may lose this initiative and slide back into some Neanderthal caveman era, which will be worse. I don't want that. Justice Chavan said trees. Yes, we do have to save the trees because we've got fewer and fewer of them. But you know what? You can go wild with the electrons. Do whatever you want. You can't harm an electron. It doesn't matter. Do whatever it is you like. Somebody sends me a PDF where the entire scan is horizontal. Okay. There's a rotate button. I rotate it. Matter's over. I don't need to reprint. I don't need to complain. I click a button. It's just rotated at 90 degrees. It's oriented correctly. What has been lost in this? Not a thing. Storage space is cheap. Hard drives can be 2 terabytes, 4 terabytes, 8 terabytes, whatever you want. And you don't need to keep it. After you're done with it, you delete it. It's stored in some central server. That's good enough for you. But for this, the idea that you will print a 300-page affidavit on paper, single side, then scan it, and then send the scan as an image to the judge so he can't mark it up. It's just ludicrous. This is not the future. It's very much in the past. It needs to be put in the past. And that's this line that I began with. The video conferencing for courts is here to stay. And I do not see how we are going to get rid of it. I'll be happy to take any questions with Justice Chavan. Sorry, I went on for a bit.
Thank you very much, Justice Patel. You and Justice Chavan have shown us a dream. Have shown us a dream today of what the judicial system could be, caring for litigants, caring for the bar, and caring for everybody and for the nation itself. I'm now requesting Julio Ribeiro, the grand old man of Mumbai, to give his comments on this, because I think he has a lot of wisdom and we'd like to draw on it. And I have deep respect for Mr. Ribeiro. Mr. Ribeiro, please. Ajay, have you unmuted Mr. Ribeiro?
No, sir. I just searching his name in the chat section.
Mr. Ribeiro, you are logged in as Mr. Ribeiro, or is there some other name? Shivam, do you know in what name Mr. Ribeiro would have logged in?
Seems to be in as PCGT. There is one person as PCGT, that's for sure.
Jay, just try the PCGT one.
Yeah, done.
Are they?
Mr. Ribeiro, I don't need to introduce Mr. Ribeiro. He is somebody who's famous across the nation.
Yeah. Well,
Right, sir.
thank you, Shailesh. I think I'd already informed through Shivam, our staff member, that we're going to log in as PCGT because, yeah, all right.
He
Uh,
did say that.
Pardon?
He did tell us. We forgot about it, sir.
All right. See, well, I'm fascinated by this webinar today, that there are things that the courts have to change, and I agree totally with Justice Patel that the COVID is here to stay. It might be modified to a great extent because human ingenuity and our scientists will see to that. But the influenza was never eradicated. To that extent, I'm quite sure the COVID will remain here. And it's a good opportunity, as Justice Patel has said, to come to some new ways of doing business. Now the PCGT works with all these young people in colleges. They all know about how to use these modern methods and these scientific methods, technology. I am totally out of date, so I'm not really competent to talk about it. But my all the students I know and who are really bright and they're really very interested and passionate about their work, I think that they will in fact find ways to help you in this matter. They have done that for us for PCGT, uh, and they continue to do it. So Justice Patel has made some very given very important uh, reasons why we should go through. In fact, Justice Chavan started telling us why it has to be done. That is what he told us, the present position and why it needs to be changed. And Justice Patel has put it in actual practice in his court from April onwards, and it has succeeded, and he has overcome all the difficulties. Because difficulties are bound to be there, there are going to be obstacles, and we'll have to go over them. One of them he mentioned was that the government may say it has no funds for hardware, but I don't think that that should be an option given to the government. It has to help the people to get quick justice, and that is what we are not getting. And if this is a method by which we can, I think it is very important to bring this thing in, bring it in operation. And we are very happy to have these two eminent people telling us why it should be done and how it can be done. And the PCGT, in fact, would be very happy to help people like Sailesh, who we are great friends of Sailesh. We work in tandem very often, and whenever he has a bee in his bonnet, we know, we help him along. And this is not a real bee in the bonnet; it is much more than that, much more than that. And we can whatever help he wants from us. Uh, I'm telling you officially, it is done. You will get that. Uh, even I don't think Justice Patel was very happy with your suggestion about more judges, but I don't think you asked for more judges. What you asked is that vacancies should be filled. And that, I think, is a very genuine concern. Why should they keep vacancies unnecessarily? And he has shown our Sailesh statistically and mathematically, because he's an IIT graduate. He keeps telling us how he can see that the pendency would reduce in case the judges' vacancies are filled. Well, that is one part of it, but I think this thing is here to stay. The e-courts, as Justice Patel calls them, is here to stay. And we should all help in this process. We should advocate it. We should talk about it. We should move the government. We should tell the people also. Because, I've seen during the COVID, the doctors, we have more a family like mine has got more experience of doctors rather than of lawyers. So we haven't gone to courts, but we certainly have gone to doctors, and we try. The doctors try not to meet us, they don't want to come personally. So there's what they call telemedicine now. They tell you on phone. And I think mostly we have never had a problem. We tell them the symptoms, what we are feeling, and they give you the medicine and it works. I've never had a problem where it didn't work, neither for me or for my wife. So I think that as far as the courts are concerned, you all are much more knowledgeable about it. You have experience about it in in the year 2020, and you can't. I think the two judges who have spoken, they have really educated us, and we can only say that we will help in whatever way we can. We have very many students. We work, as I said, with students. They cut across all the colleges of Mumbai, mainly the law colleges, and they are we find them very, very passionate if you give them some tasks to do when you open their minds to ideas, and this is an idea that is worth working for. I think that I will not be able to speak longer than this, and whatever time is available from my 10 minutes, I lend them to my friend Sailesh when his time comes. Yeah, all right, to speak. Thank you.
Thank you very much, Mr. Rivero. You've been very kind and it's great to listen to you. Now, with the permission of the two honorable judges, shall we take questions and answers, sir? The questions have been taken in the chat box, and Ayush, Ramesh.
Sorry, Shailesh, may I just say this before we go?
Yes, sir.
Just two things I forgot to mention. I think Justice Chavan will agree to supplement this. The e-court may have a difficulty in trials, possibly criminal trials, where the accused is still in jail or incarcerated, because I haven't yet figured it out. I'm sure there must be a method, but I don't know how that accused can readily communicate with his advocate when a prosecution witness is being cross-examined. I think that's one gray area that still needs to be worked out. I don't know whether there's an effective protocol, but it's a serious concern. There are issues of confidentiality, attorney-client privilege, the need to have your client next to you when the cross-examination is going on. In a civil trial, let me tell you, this isn't the first time at all. In fact, I've got a civil trial to start by video conferencing in February because the witness has requested it. He's in London. He can't travel. He is a doctor. Both sides have agreed. They've put in place protocols following the Supreme Court guidelines, following them exactly to the letter. So we've followed those. In fact, let me tell you, the very first video conferencing cross-examination was in 2014 in a very old case, because that witness was told in a 1980s case that nobody could give him a time and he had to come to Bombay and wait. So I asked the Chief Justice at that time, Mohit Rao, whether we could do this. Both sides were agreeable. They agreed. So he sat in a supervised area in Geneva. We coordinated the time zones. And we were in the conference room in the Bombay High Court, and we finished the trial in that fashion. There's no problem. And sorry, this came in just as we were discussing this. I must tell you this. Justice Zavan, you'll be interested. My court clerk has just sent me the statistical disposal figures from 1st April to 18th December. Apparently, I think he may have got something wrong, but let's see. Apparently, there were 1,948 cases listed before me in this period. About 9 of them I couldn't hear because I knew one or the other of the parties. But the total that I took up were listed were 1,948. And the total disposals are 903, which is about 47%. Now, I don't think I could have done this in a physical court. That's my point. That's the point I'm making. It just went more efficiently. And I'm sure that this is true of all my colleagues, many of them, in fact. I see no reason why it shouldn't work. I'm not saying these are exceptional. I'm saying this just came in, so I'm reporting it.
Right, sir. Ayush, Ramesh, and Shreya are going to read from the chat box and put the questions to the judges. If possible, they will say it is for a specific speaker, but at some times they may find it difficult. Jay, please unmute Ayush and Shreya. Srividya. Are they unmuted?
Yes, sir. Yeah,
Both
yeah. I'm.
Yes.
Thank you. Go ahead.
Ayush Ramesh, I have sent you the request to unmute yourself.
And Jay, keep the two speakers unmuted completely now.
Okay, sir. Okay. Yeah, you both can unmute yourself. I have given you the access.
What happened?
Hello.
Uh,
Yes, sir. Am I audible now?
Yeah, go ahead.
Yes. Okay. Our first question is by Advocate Sri
A
Nazir
little
Khan.
louder.
Yeah. Our first question is by Advocate Sri Nazir Khan. He asks, even if artificial intelligence technology adopted to speed up the process, the same can only be useful for pre-delivery judgment stage. But in my view, it cannot substitute for the increase of judges' strength for the disposal of cases. This question is addressed to Justice Chavan. I request Justice Chavan to please address the question.
Artificial intelligence will not be able to release judges. That's true. We are about using virtual courts for making more judges available. We are going to use intelligent scheduling for ensuring that the judge time is used more efficiently. This is not about artificial intelligence. Artificial intelligence is something else. Artificial intelligence will only help judges and lawyers to be equipped with all the necessary legal databases so that they don't miss anything when they decide a case or when they argue a matter. Artificial intelligence is not about releasing the judge time or increasing the number of judges.
Ayush, I want to supplement what Justice Chavan said. This idea that an artificial intelligence algorithm will predict what Justice Patel is going to do in a case where Justice Patel himself doesn't know what he's going to do is absurd. That's not the purpose of it. You can take 10 of my previous judgments and you'll still not know what I will do on Monday morning. Some of that may have other factors. It may depend on how good a breakfast I've had. There are too many moving parts. There may be too many moving parts in this. There's nothing to do with this. What Justice Chavan is telling us is this, that if I'm dealing with, okay, since he's mentioned trees and forests, I want a collation of all the judgments that relate to a forest issue or particular dimension of forest issue between the Bombay High Court and the Supreme Court. So I am fully informed of the state of the law that I'm dealing with. The reason that the Chief Justice of India is saying all of this is that it allows us to then deal with the completeness of the law as it stands, makes for a judgment that is more comprehensive, more accurate. That's the thinking that is behind this. Secondly, that you can intelligently schedule cases depending on a variety of parameters. You can club them, delink them, list them all together. You can do a variety of things. That's the purpose of the artificial intelligence mode that the committees are talking about. Also deciding which matter requires more process, less process. It's not about predicting outcomes.
Yeah.
That's the point. It's not about predicting outcomes. Nobody's predicting an outcome here. Sorry.
Next question.
Thank you, Justice Patel and Justice Chavan. Our next question is, some of the senior advocates indulge in delaying tactics and ask for postponement, which puts their client to greater mental agony and huge cost of travel to and fro from to the Supreme Court in Delhi from all parts of the country. How do we deal with this? This question has not been addressed to a specific speaker, so I
Justice
request.
Chavan, you have the advantage of being in retirement, so you can answer this one.
Okay. Okay. See, e-courts or courts by video conferencing will eliminate this issue. Will avoid a litigant being required to go to Delhi, etc. Secondly, as we are trying to push live streaming also, so that a litigant will come to know what his advocate is doing. Today, what happens is many times the advocate does not, the client does not know that advocate is going to seek an adjournment or he's not at all going to appear. Sometimes the advocate takes a brief, but is not before the court. So all this can be avoided if we have got uh, virtual hearings which are live streamed, so that the client comes to know what is happening. You can't keep a client in dark about anything. See, today, unfortunately, what you say that some advocates may be indulging in such practices, no doubt, but this is because of the compressed field. What has happened is the number of cases is shrinking. People are going to extrajudicial authorities or extra constitutional authorities for solving their problems because of the delays in the courts. If the system is more efficient, people will come to the courts. Because the number of cases are less, advocates tend to cling to their cases. They don't want to give up. They want to stick to the case till the final milking is over. So this happens because of the shrunken size of the bread and more mouths to feed. Every year we have got about 15,000 lawyers enrolled in the bar, new bar enrollments. How do we provide work to them? If we snatch the work from extra constitutional authorities, that is goons or people who decide cases otherwise, then again we can provide work to them, everyone, and then there will be enough work. No advocate would cling to a case. No advocate would indulge in these practices. Therefore, we need to make the system efficient. Thank you. It's a good question.
In fact, that question more or less answers itself, because this was truly a situation that happened in physical courts, but there is no empirical evidence that it has happened in virtual courts or in e-courts. None. In fact, my experience is the reverse. No lawyer is asking for time unless he really needs to put in an affidavit or has received a document. They are not asking for time on the basis that, oh, I couldn't make it, I'm busy in another court. If you give time slots, that's my experience, I'm not speaking for anyone else. If you've given time slots, at best, 5 minutes, 10 minutes, pass the case over, he comes back, he's not asking for time. That's not been my experience at all in these last 10 months. No senior lawyer has done this. And the other thing I have told the senior lawyers is that I have now got a schedule. I take the final hearing cases in the afternoon. You adjust your diaries to my docket because you have the option of saying no to work. I don't have the option of saying no to work. I will not change my docket to your diary. Finished. That's the end of that. Everybody has followed that discipline. A lawyer can say no to a brief. How do I say no to a case that is listed before me? I don't have the choice.
Yes, Ayush or Srividya.
Yes, thank you, Justice Patel and Justice Chavan. I would ask the next question now. Mr. Rashid Yusuf from Andaman Society for Fast Justice at Port Blair has asked that there is no regular court at High Court in Andaman and Nicobar Islands. We have 572 islands, out of which only 39 islands there are people living, and these islands come under the jurisdiction of Kolkata High Court bench. We have faced difficulties as we do not have a virtual court. And are we to travel long distance to the Supreme Court? Can Supreme Court suo motu issue orders for virtual courts? They need help and support for virtual court at Port Blair. On the point of standardization of procedures, I request Justice Patel.
One by one.
Sorry.
Let's do it one by one. The second question we'll do later. Standardization we'll do later.
All right.
This is the court infrastructure issue.
All right.
See, on Andamans, there is a problem of connectivity. Okay, but we are resolving it. very shortly we have satellite connectivity, and therefore Calcutta High Court, some judges of Calcutta High Court actually go to Andaman once in a while. There is a circuit bench there, but then this will be eliminated. Ultimately, you will be able to access the Calcutta High Court every day, 24/7, or even the Supreme Court, once we have that connectivity issue solved. Right now, there are some what they call is TNF sites, technically non-feasible sites. We are after them. We are going to ensure that all technically non-feasible sites become feasible. There are some places in Andaman, some places in Northeast, some places in Jammu and Kashmir also, where this feasibility, that is, connectivity problem is there. We'll resolve this. By the end of this financial year itself, that is before 31st March, I suppose the issue should be resolved. Let us hope. Okay, because government has promised that it will do it.
But it may not be peculiar to Andaman. You may have people in remote parts in central India as well who will face the same problem.
Judge.
Central India, Jammu and Kashmir will face it everywhere.
So, Judge, don't be surprised if I tell you that there is a place in Bombay which has been certified as technically non-feasible. Dongri. There is a court in Dongri.
Fantastic.
And the Bharat Sanchar Nigam has certified that it is technically not feasible.
But that's not for reasons of connectivity of laying a fiber optic cable. That's for a totally different reason.
There is a court in Budhana city, which they have not connected, saying technically not feasible. Anyway, these things we are trying to resolve these issues. They will be resolved. We are after each such site which is technically not feasible.
Srividya, next one.
Sir, I'll be asking the question. Thank you, Justice Chavan. Our next question is from Dr. Wagle. He asks, in recent times, the case files have been scanned and are available electronically, but has there been a project to scan the older case papers? More importantly, in the case papers which are older than 20 years, as they are at a higher risk of becoming degenerated.
Yes, that's going on. It's an ongoing project. It takes time, but it's an ongoing project. See, it's not just a question of scanning. Justice Chavan will tell you. There's an attendant problem of taxonomy. When you scan a sheet or a file, a plate, a petition, you have to number it in a particular manner. It has to be stored in a retrievable manner. Otherwise, it's garbage in, garbage out. It just can't be scanned and dumped there. And it has to be rendered in 4 different formats. One is the original with all its markings, endorsements, handwritten endorsements, changes. The other is a cleaned up version. Then there is one that is accessible for the judges. So all of this complexity has been worked out. Entire records have been called for, and they've been scanned in sequence. So first you've got to set that record in sequence, then scan it. The problem with the high courts is different. Once you've scanned it, because we are a court of record, all high courts are a court of record, can we destroy the physical papers, or can we not? Big question mark. We're still not clear on this. Yes.
Yes, Ayush or Srividya?
So the next question has been asked by Mr. Vivek Yadav. He asks, will virtual court help in increasing virtual accountability? This question has been addressed to Justice Patel.
I don't know what that means. What is virtual accountability? It's just
virtual judicial accountability, I believe.
I don't know how it makes any difference. It can make no difference to that. You are free to walk into a physical court. You are free to go to a virtual court. I don't think there's any impact in that direction at all. I don't think it has any impact. None there.
Next question.
The next question is by Mr. Utkarsh Singh. He would like to he asks, how will the virtual courts eventually reduce the human touch of explaining and presenting documentation, as human presence is required for the same?
Sorry, why is the human presence required? I can read
for
somebody. No, I don't need. No, I'm sorry. The lawyer gives me written submissions. I have his pleadings. I, as a judge, am supposed to be able to discern from this the right way forward. In fact, you go to the US Supreme Court, their oral arguments are time limited, means they ring a bell and hammer it down and they close it out. We started doing this in the Bombay High Court. Put in your written submissions and limit your oral arguments. So two sides in a matter said, all right, we put in our written submissions. I said, how much time do you need? They said 45 minutes each. I said, you have 20 minutes each. With your written, you can't have both. They actually wrapped up in 11 minutes each. They wrapped up. There was nothing to it. There's no great thing that physical presence can explain something that you can't do in a virtual court. Ask the lawyers who are appearing. They're saying they're able to do it just as effectively and their arguments are more concise. They are also battling the technology and disruptions and so on, so they want to be concise as well. They're happy with this. This is a mythology that a physical thing lends some great quality to the decision-making process. In a given case, it might. Not all.
Thank
Yes.
you. Thank you for the answer. I wish to ask a question which is twofold in nature. This is my question. The first, pertaining to the rights of the accused, and the second pertaining to the duties of magistrate per se. So the question is that so the accused have the right to refresh the memory, or they also have the right to give the testimony under the guide, I mean, in the presence of the magistrate, because the magistrate has to examine the demeanor of the accused. So will virtual courts be an impediment to the same? Because if they have the right to refresh memory, there is always a possibility for them to cheat. I know that for sure since I am a student. And on the other hand, will the accused face any threats, because something that happens behind the camera cannot be possibly examined? So
That's precisely the problem that we just discussed, that in criminal matters, there are issues not yet resolved. We have to get protocols. There's a lot of discussion required for that. It's not a straightforward thing at all. Justice Chavan may have a different view on this, but I think it is complex, and these precautions do have to be put in place. They do have to be put in place.
Shri Vidya, first, remember this, that confession of an accused, even before a magistrate, can be retraced. Okay.
Retracted anyway.
Retracted. Therefore, there is no question of confession being the sole foundation of a conviction. One. Two, about demeanor. No, demeanor is an extremely deceptive thing. Somebody looking at you in your eyes and telling you something, it's not necessarily truth. No. Somebody being hesitant to coin words or trying to find out correct expression because he's not familiar. So I'm not as fluent as Justice Patel is. So it doesn't mean that I'm trying to make up a story, no? Isn't it? Both are speaking out of fullness of heart. But only thing is that maybe I lack in expressing. I have to find out phrases. You heard Nehru or Atal Bihari Vajpayee?
yes.
Yeah. Try to recall their speeches. How did they speak? Did they speak like present Prime Minister Modi? No. They took pauses. Were they trying to con people? No. So therefore, it's a question of everybody's way of communication. The demeanor is the most deceptive thing. Don't depend on, no judge, no magistrate should depend on demeanor. So recording demeanor of witnesses and all that is all humbug. It doesn't help.
Complete humbug. Unless that witness is palpably lying and trying to deceive the court or mislead the court, there is no value to this at all. None. If you know that he's trying to be shifty, it needs to. It's an exception. In 7 years, I've noted demeanor once. Once.
All right. Thank you so much. And I believe Ayush will ask the last question now.
Yes, thank you, Justice Patel and Justice Chavan. We will be taking one last question. It is by Akhil. He asks, is it viable to conduct trials in e-courts where recording of evidence and cross-examination is conducted?
Why not? Why not? If if for some reason the parties feel that a person must be physically present in the court, they may make out good grounds for that. No, otherwise all evidence, 90% of the evidence can be taken virtually. There may be 10% cases where physical presence of the person may be felt necessary by the advocates or by the judge. That could be done. Otherwise, a police officer who has recorded statements of witnesses, who is investigating officer in the case, why can't his evidence be recorded virtually? An eyewitness, maybe a victim, we may require his presence in a good case. That also not in all cases. 90% of the cases that will not be necessary. Therefore, that depends on case to case. You read Michael Sandel, what is the right thing to do? There are a lot of videos also of Michael Sandel. Okay, so see those videos. The right thing to do in every situation is different. As Justice Patel said, no, 10 judgments in 10 cases he may have decided one way, but in 11th case you can't predict. Likewise, what will happen? How should a judge react in a particular case? We are not machines, no. Otherwise, we can delegate the task to the computers itself. No?
Correct. Nobody is suggesting that. And where is the question of can it be done? It has actually been done. In the UK, they finished entire trials by this. And as I told you, in my case, in a civil trial, there is no issue at all. There is no issue at all. I've got one scheduled with the permission of the Chief Justice in February. There is no difficulty with that. I've done one in 2014. The trial was over. Parties agreed. What's the difficulty? There's no problem to it. Technically, there's no problem to it.
See, Ayush.
In case you may have a problem.
Ayush. In Alibag, an entire sessions trial was conducted before Judge A, Session Judge, and he was transferred. And Session Judge B only read the evidence and then delivered a judgment. So, if this can happen, this can be permitted to happen, there is no reason why virtual evidence cannot be taken, isn't it? And it's in fact better because in such a situation, the judge at least can again go through the videos and then decide for himself what he has to, isn't it?
Yes, sir.
So, if we can read testimony, an appellate court reads only testimony paper, no?
That's right.
Thank you, Justice Chavan and Justice Patel. That was our last question. Over to you, Mr. Chavan.
Thank you very much, Ayush and Srividya. This was very lovely. Thank you for your support. Now I'm going to go towards the end. First and foremost, Justice Chavan and Justice Gautam Patel have shown us what can happen. And I'm submitting that citizens need to take this forward. All of us need to take it forward if we care for India. Patriotism is not merely standing next to the flag. Patriotism is seeing that India becomes a better country. And if we can change our judicial system, we can make our judicial system better. We can save thousands of trees. I think that's the way to go. And there is no reason why we can't. My submission is, I'm hoping that people all across the country will have 50, 100 such seminars. And the courts will listen, standardize everything as they said, and bring that change. The pain of waiting for the justice to get delivered leads to unconstitutional means for resolving things, which is not desirable, as Justice Chavan said. And I'm sure we'll keep getting the support, moral and actual, from Justice Gautam Patel and Justice Chavan. On the small thing of the judges, I have two different judges who have different views, but that's fine. I still do believe that if we filled up our sanction positions, we would not have backlogs. But having said that, let's leave that. Thank you very much, Justice Patel and Justice Chavan. And thanks to all the participants and both the organizations for supporting this. I look forward to making this a national agenda in the next few months. If we do it, otherwise, if we don't do it, we'll have missed the bus. I believe some courts have now gone back to physical. unless we put up a strong argument, we will lapse into the good old bad ways. And that would be a disaster and that would be a shame. Thank you and a Merry Christmas and season's greetings to everyone. Thank you very much.
So, Sharima, should we end this?
Yes, thank you.
Should we end this?